Vaishali, we are all set. We are live. Go ahead.
All right, thank you. Good evening, everybody. Welcome to IIGB's Estate Planning webinar in collaboration with South Asian Bar Association of Greater Boston. I'm Vaishali Gade, Vice President of IIGB and your host and moderator today. Today we have Vaishali Goyal with us. She is a private client attorney focusing on the income and trust and estate planning, tax efficient family wealth planning, and charitable giving, as well as nonprofit matters at Goldstone and Stores in Boston. Along with her, we have Suma Nair. She provides sophisticated estate and tax planning advice to high net worth individuals and families. She is a director and private client trust attorney at Goldstone and Stores. When it comes to trust planning, I know for many of us, it's a very complex topic. And on top of that, for us, Indian Americans living here, it becomes even more complex because we have inherited properties, maybe properties that we bought back in India, and then whatever we have gathered here. So the trust planning is really, really very important and essential for us at least. And to help us in that matter, I know this is just a starting point, but I'm hoping Suma and Vaishali can point us in the right direction, and then we can take it from there. The way today's evening will flow is Suma and Vaishali are going to give us the presentation. We have received very many questions from you who submitted ahead of time. They have tried to incorporate many responses to those questions in their presentation. But apart from those, if you have any further questions, please put them in the chat window and we'll try to address them at the end of their presentation. So with that said, Suma and Vaishali, please take it away.
I always forget that. Thank you, Vaishali. Thank you for the introduction, and thank you to the Indian Association of Greater Boston and South Asian Bar Association of Greater Boston for inviting us to speak on what is a very important topic of estate planning. And we hope we can get you where you need to be to get you started. Just to take care of some housekeeping before we fully get started, we're here to talk about, very basic estate planning concepts with a touch of dealing with, inherited Indian property that you may hold. So while this may be of obvious interest, it is intended for general information only and should not be relied upon as legal advice as facts and circumstances may vary. We also want to note that tax reform is on the horizon, and we only present on the law as it currently stands. We also present on Massachusetts law, as this is presumed to be, in the Boston area, Massachusetts. But please note, if you're thinking about planning for someone else and they live not in Massachusetts, they may have to think about getting separate counsel and dealing with another whole set of laws. So prior to taking or refraining from taking any action, please consult your own legal counsel. And like Vaishali noted, we received many questions before the program, and we incorporated them all into our program, or they will be addressed by Suma at the end. So please submit any questions you have in the meantime. But now that we've taken care of the housekeeping, let's get started, and Suma will kick us off.
So welcome, everybody. I think whenever we start a conversation about estate planning, people say, do I need one? Is that something I need to have? And it's really important to understand that everybody on this call has an estate plan. You might not know it, but you do. And if you haven't gone through the process of actually preparing a will and a trust and all the other documents that Vaishali is going to speak about right after I'm done, you should understand that the Commonwealth of Massachusetts has laws that are your default estate plan. And those are the laws of intestacy. And so what that will mean is that if you don't have your own estate plan that you prepared with counsel, you are going to simply have a default statutory process by which your assets at death will be transferred to family members. And it may not actually reflect your wishes or what you would like to happen. So that's the reason that Vaishali is going to go through the basic estate planning documents that one would ordinarily want to have in place so that you're not relying on Massachusetts state law. Take it away, Vaishali.
Thanks, Suma. So typically what we package in an estate plan document are 6 documents. So it has a will, a trust, which I think a lot of people are sort of familiar with the concepts, but there's also really important documents called the durable power of attorney, healthcare proxy, living will, and a HIPAA authorization. And we'll go through each one. But all of them together answer three main questions. One, what happens when you're alive but incapacitated? So this could mean, what if you're in a coma or you're simply traveling and you can't sign some documents that may need to be signed? Without incapacity documents, which I will talk about, what happens is a court will step in and actually appoint someone to act on your behalf in those specific situations. This can be burdensome, inefficient, and not actually get you to where you need to be or where you want to be, more importantly. So what we sign in these instances is a durable power of attorney, a healthcare proxy, a living will, and HIPAA authorization. Those are the incapacity documents that will address that question. Second question, what happens to my children after my death? This is something that's on everybody's mind, probably more so than, what if I'm incapacitated? And what happens here is that if you don't have a will naming a guardian, the court will ultimately decide who gets to care for your children, which may not be who you think should be caring for your children, right? And that's an important thing that the will address. And secondly, something that some people don't think about very often, but it's how do you want your children to actually receive the inheritance from you? Some people have minor children and it may seem more obvious that, I don't want to give my 5-year-old, let's say $500,000 in cash upon my death. But do you want your 19-year-old or 20-year-old to also have that kind of access to money? I don't know. You may not. Many people don't, not even when they're 25. And that's important. And that's something that you can use the trust for to help navigate that process as well. So it's important to have both of these documents in your estate plan as well. And lastly, how do I minimize estate taxes so I can maximize the assets actually passing to my loved ones, right? So let's take a moment to talk about estate taxes. On the federal level, you will only get taxed for an estate tax if you are above currently $11.7 million. This is a huge amount, but you will only get taxed at a flat rate of 40% if you have above $11.7 million as of now. This is scheduled to be cut down to probably approximately $6 million in 2026. But like I mentioned before, there's tax reform on the horizon and we don't know what's going to happen. But right now we know it's 11.7 million on the federal level. Then there's a state level tax for all of those living in Massachusetts. It has a graduated estate tax, which means as to all amounts, sorry if you can hear other noise, as to all amounts in an estate above $1 million, the effective tax rate ranges from 10% to 16%, with the 16% only kicking in about 10 million after $10 million of your estate. So that's a little bit about the estate tax, and we don't go too much into it because we have a lot to cover, but that's a little bit to give you some background. And you can minimize the value of your estate with certain deductions, particularly the marital deduction, which will come into play for a married couple in which both spouses are US citizens. If one spouse is not a US citizen, you will need special tax planning put into your overall plan so that you can actually utilize that marital deduction. Otherwise, it won't apply, unfortunately. And then you can always use some charitable deduction, which we will address later on also. So otherwise, at your death, any assets that do not have a beneficiary designation, a payable on death designation, are otherwise not held in trust or not joint property will go through that intestacy process that Suma mentioned earlier, which is just they will flow by the laws of Massachusetts and will end up where they end up depending on your family makeup at the time of your death. So if you don't have a plan in place, you won't have a say in all of these very important decisions. But you can have an estate plan to make all those decisions and have everything play out almost in the way exactly that you want it to. So going back to the first question, what happens when you're alive but incapacitated? So these are the incapacity documents. First is a durable power of attorney. So this helps you name an agent, and that person can basically take care of financial decisions for you. So they will be able to sign checks for you, sign a tax return if they need to, things of that nature that help you manage your financial assets. And this is important because sometimes you just can't get to the bank and sign something that you may need to sign. So it's important to sign, appoint someone that you trust and that you know that will actually take care of your financial assets well in this position. Second is the healthcare proxy. This addresses the situation for when you're live but medically incapacitated. So people may think that when you're incapacitated lying in a hospital bed, for example, your spouse is automatically your healthcare agent. That's not true. You need to actually appoint your spouse as your healthcare agent for them to be able to make decisions on your behalf. This is already a very stressful situation. You don't want to have to go ask the court or have the doctor go. Get a healthcare proxy, appoint them, and everything will be much smoother. You can appoint a non-US citizen. The doctor just needs to be able to contact this person. They don't even need to be in Massachusetts. It's just a phone call away. And this is effective upon your incapacity. So when you are actually medically incapacitated as determined by your physician, then this appointment will kick in, and then your agent under your healthcare proxy will have the ability to make those decisions. Third is a living will. So this is a document that gives guidance to your healthcare agent as to how you would want them to make decisions in those really tough situations, right? So you can tell them, I know a lot of doctors and nurses or people in the medical field who are clients of ours may have a lot more specific requirements in their living wills that say, I want, if I'm on XYZ drug, I want ABC to happen or such. You can write all that guidance in this document to your healthcare agent or to anyone else in your family that you want to generally know what your end of life wishes are. Our typical living will state that if I'm terminally ill, I want full pain relief. I want to be comfortable, but it's okay to let me go. Right. And I think that's what a lot of people come down to. And I think it gives, sometimes your healthcare agent knows, but you want to give them that comfort that you were okay with it. You wrote it down, you told them that, and it's comforting. And it's not legally binding in Massachusetts. So, your healthcare agent is not forced to make that decision. She has, he or she does not have to say exactly what's on this living will, but they know what you were feeling when you were, fully at full capacity and knew what you were talking about. Last is the HIPAA authorization. So many of you may be familiar with HIPAA. It stands for Health Insurance Portability and Accountability. So this authorization would give certain individuals access to your healthcare records. This is super important, particularly for your healthcare agent who won't be able to make the decision on your behalf if they don't have access to your medical records, right? Because the doctors are required to protect that. And as a note, it's important for your adult children to sign HIPAA authorizations too, because for example, when they go to college, you may think of them as your child because they are, and they may be a child to you forever, but the doctor that they will be seeing, outside, let's say they go to school in Colorado, will not be seeing them as your child, will be seeing them as an adult who has privacy or who's entitled to privacy for their medical records. And you need to make sure that you are actually authorized to gain access to that. Okay. And so the second question we had was, how do I minimize taxes and take care of my children? This is where the will and trust come in. So your will governs what's called probate property. And I described this earlier. It's any property that is not held jointly, does not have a beneficiary designation, and is not owned by a trust. So essentially, it's any property that doesn't automatically pass somewhere upon your death. So just because you have a will does not mean there won't be a probate process. You will have probate property. You can try to make all of your property not probate. Suma and I are actually working on a case where we really tried to do that, and we somehow still found some probate property. So you really want to make sure that you don't assume that there's no probate. You work hard, but that will be what's involved in your probate process. This is a document where you name the guardians, as I mentioned before. And again, here you can name a non-US citizen. However, a guardian will be appointed by the court, and the court may impose some onerous jurisdictional requirements on a guardian who's not a resident of the US. They think about what's best interest for the child and what will, they don't want to uproot the child's life to have them move to, for example, India or somewhere else. So you may want to think about that when you're thinking about non-US citizen as your guardian. The will is also a public document. So what our typical plan, what it does is actually pour over all of your assets from your will into a trust. So that way you could dispose of your property in the way that you like, and nobody needs to know about it. Just, your family and the people involved need to know, and that's okay. So what we pour this into is called a revocable trust. And I think some people who submitted questions refer to it as a living trust. So this document is private. It can only be read by the people who are basically named in the document, who have any entitlements under the document. So the trust itself can keep assets for the benefit of whomever you like. Our typical plan is that you, upon your passing, if you are married, will be held for the benefit of your surviving spouse, and then upon their death, it'll be held for the benefit of your children. Again, like I mentioned before, there are special trusts for non-US citizen spouses. It's what's called a QDOT, Qualified Domestic Trust. And that will be something you will work on with your estate planning attorney. But just as a note, that will be something that's slightly different, but also a trust. And the advantages of keeping assets in trust is that first, there's protection from creditors and divorcing spouses. And this is important because, let's say there's a bank who needs to collect on something. It's much harder for them to get assets in a trust that is actually protected by that entity and is not just owned by you individually. And then secondly, there's protection for tax character of the assets in the trust. We won't go into it too much, given again that we have a lot of information to get through, but essentially down the road, it can help your descendants pay less tax, and that's important. And if that's really important to you and it seems relevant, definitely go talk to a tax planning attorney or an estate planning attorney who does sophisticated tax planning, who can help you address that. And like I mentioned before, a trust is a great vehicle to pass your assets to your children who are not minors, but still too young to receive a full inheritance outright. And assets or estates vary, from people to people, could be small, could be large, but any amount may be too much for your 20-year-old, even 25-year-old. And a trust can help you give those assets in a more responsible way. So that way there's a trustee who is holding the assets for your 25-year-old's benefit, who can distribute the assets based on what they actually think is necessary and good for the child. So, and if the child's a minor, they can work with the guardians to make sure that the guardians are taken care of and all the added expenses from having, essentially adopted another child, or anything else that's down the road that comes up that's just an added expense. And the trustees can help supplement that, which a minor child holding $500,000 cannot do. So there's a lot of advantages into keeping assets in trust as opposed to distributing outright, which I think a lot of people think is a normal plan or something that they have to do. You don't have to. And this is addressing a question that came in. A lot of people in what are called community property states utilize joint revocable trusts. We in Massachusetts typically don't use such trusts. We instead use separate revocable trust for each spouse, as it generally serves better tax efficiency, at least in Massachusetts. So if there's any follow-up question from the person who had submitted it, that's what's relevant there. So now moving a little away from the basic estate planning, the next big question that we wanted to address in this presentation is, does it matter if I own property in India? And I know that's what a lot of you have on your minds. So a very simple answer is that all of your worldwide assets are taxed here. All the rules apply. So you can give anything you have to anywhere you have. It's all the same. It's all taxed the same way. The US does not care where it's located during your lifetime. So make sure you have a CPA who's very familiar with these rules, because they are complicated, and TurboTax is not going to cut it. You got to get someone with knowledge and expertise on this. And then on the same token, or by the same token, upon your death, you need an estate planning attorney to be able to deal with the consequences of having property in India. It is complicated, and we cannot comment on the inheritance laws in India or Pakistan or anywhere else in South Asia. You need to get Indian counsel to deal with the property there. It will not be cost effective for you to just have US counsel and just have a US will to deal with your property in India. In both on the planning and administration side, it won't be cost effective. The Indian attorney will be able to tell you about the rules and what the most tax efficient way may be for you to plan your property over there, which may be different than here. And this is possible, as counterintuitive as this may sound, you can have two wills. So you can have a US will governing just your US property. So it would be defined in your will that this will governs all of my worldwide assets except my property, for example, in India. And then your Indian will say the same thing. It governs my property, or the converse thing. It governs my Indian property, all the property that's located in this country. And that is how you can have two wills. It seems counterintuitive, but you can, and that will be the most efficient way for you to do just all of your estate planning. So you have one will that makes sure that your plan is very tax efficient and what you want for your assets here. You have another plan that is the most tax efficient and other types of efficiency that you may need in India. And let me just catch up with my notes here. And on the administration side, then when you pass away, it will also be so much easier for the people that you nominate as the people in charge of actually administering your estate. You know, the person you nominate here is probably not going to know about what to do with all of your Indian assets. You want someone who is familiar with the rules there, familiar with your assets there, and can deal with it in India and best know how to deal with that property. It will also be more cost effective that way too, because I can't imagine the amount of time and money it would cost to have someone here try to become familiar with the rules in India and what to do there. So the point of all of that is how to deal with property in India, get an estate planning attorney and have them help you figure out what you need for there, because it really seems like you do need an Indian will. And secondly, or the next question is, what if I'm not a US citizen, but am a green card or visa holder? And again, it goes back, everything is taxed the same. The US does not care if you're a citizen. If you're here and you're residing here, you are a US person and you are taxed. So you get all the taxation, but unfortunately, not all the benefits. This is how things always fall, is it not? So one of the benefits that you don't get that I mentioned briefly before was the marital deduction. So what happens here is that in conventional cases, when both spouses are US citizens, any transfer between them is not taxed. During lifetime, there's an unlimited marital deduction. You can give to your spouse anything you want. It's no problem. Upon your death, you can give to your spouse and it's not a problem. Nothing is taxed. It will all be taxed on the second spouse's death without any issue because they're both US citizens. When one spouse is not a US citizen, it's limited in various ways because the government is afraid that the citizen spouse will give money or assets to non-citizen spouse. And then that non-citizen spouse might just leave the country with all the assets and never get taxed on it. So the government's very concerned about that. And because of that reason, does not give non-US spouses the full benefits of a married couple who are both US citizens. So some rules that there are during life, there's not unlimited transfer. It's limited to $159,000 a year that you're allowed to give to your spouse without taxing or without taxation. And more importantly, at death, there is no marital deduction at all. You will be taxed on it unless you have some special tax planning in place. And there are trusts that can do this. Like I mentioned, it's called a QDOT. And your estate planning attorney will be able to draft that for you and make sure that happens. So that way your plan is still a tax efficient plan. You just need to jump through a couple more hoops to get there than a US citizen married couple. And depending on the size of your estate, that could be significant savings. So don't underestimate how much this can actually, save you down the road by just putting in a little bit of cost now. So moving on to support, how can I support charities in India? So during life, there's no charitable deduction allowed for gifts to foreign charities. You can get a charitable deduction for US charities. And as a note, when we spoke about presenting, I think Sanjay had mentioned certain charities that were reaching out and maybe asking questions. Ekal Foundation and Vision Aid are US charities. So if you donate to them, you can take an income tax, a charitable deduction on your income tax return. And alternatively, if you still want to donate to some foreign charity, there are certain what are called donor advised funds, otherwise called DAFs, DAF, that make grants to foreign countries or foreign causes, sort of like you would just make it through them. Or there are what is called a Friends of US charity. So these are charities that are set up that are essentially mimicking that foreign charity, but are set up under US laws and are recognized as a US charity. Some examples are Give to Asia, and that's 2 with a number 2, and then CAF Charity Aid Foundation. And both of those benefit Asian causes abroad. So you can donate to those, get your charitable deduction on your income tax return, but still benefit those, ultimately foreign charities and foreign causes that are important to you, while still having some, tax advantages there. And at death, you can actually support any charity of foreign or US and get the charitable deduction. The distinction goes away and it's not a problem. So next is, how can I support family members and friends in India? This is always obviously a very prevalent topic in mind. So during your life, you can direct gifts under of up to $15,000 under the annual exclusion. So if it's under $15,000 within 1 year, you don't have to report that to the government. You don't have to file a gift tax return, and it's a gift, and it's basically free in some way. If it's if two US citizen spouses want to gift to someone, they can make a combined $30,000 gift to someone. And that's okay too. So it increases the amount that you can give to a person in India, which is nice. And these gifts that you are giving to people in India or anywhere else, you can also gift in the US, it's not considered income to the recipient. So they don't have to worry about, they have to go fill out income tax return now and show this gift. None of that. If it's under $15,000, it's all good. So $15,000 is the magic number. And when you're over 15K in 1 year to that one person, you must file a gift tax return. But that doesn't mean that you will actually be taxed on that gift. That will just start chipping away at the exemption amount that I mentioned earlier, that $11.7 million. It'll just start chipping away at that amount first. So unless you've gifted over $11 million as of now, you should be fine. It will all work out, but you just have to file a gift tax return to actually show that, you did gift, let's say 20,000 to mom in India, okay? And you can also make direct payments to qualifying medical or educational institutions, whether in the US or in India, which is a nice way to, if you have, let's say, a niece or nephew who's attending college in India, you can pay their bill, not through the child. You have to just pay the institution itself. Let's say it's India University. You pay India University, you pay that bill, and that's not counted. That's just a gift. You don't have to report it. You don't have to do anything. It's all taken care of. And that's a really easy way to support someone in India if the situation, fits what you need. And once you're ready, how do you get started? So if you can contact an attorney who has experience in international law, who can get you started on what to think about more specifically in your South Asian assets. The US counsel can refer you to an Indian estate planning attorney if they happen to know some, or you can just go directly and contact an Indian estate planning attorney if you happen to know one or your friends know one. And referrals may come from, your investment advisor, accountants, business lawyers, insurance advisors, friends, colleagues, and of course us if you need a lot of help trying to get there. But a lot of people have this in place, I'm sure, and I'm very optimistic that you will find someone who will be able to do all this planning for you. And I got through the presentation part. I'm really proud of myself. I got through it faster than I thought I would. I hope I did not go too fast for people. But now I'm going to kick it back over to Suma to take over some more of the specific questions that we received before the program started.
Thank you so much, Vaishali. That was excellent. A lot of fast talking, but hopefully everybody caught everything. And I see that this recording will be available later on YouTube, so people can watch it again if they have a specific item that they want to listen to again. So we were so fortunate to receive several great questions from all of you prior to tonight's presentation. And so I'm going to just cover a few of the ones that we received prior to the start of the program. And then I believe other questions that have come in will be moderated. So I'll hand it off for that piece of it. But one of the questions we received was whether there is a correct or a right entity to use if extended family members want to try to co-own an investment property such as real estate and be able to own it together and enjoy the upsides and any expenses of that property together. Generally speaking, we would typically advise use of a limited liability company for something like that. Those are referred to commonly as LLCs. And the reason for that is that LLCs provide limited liability, as their name suggests. And what that allows you to do is to protect assets outside of the LLC from any claims that might be made if there is a claim against the actual property itself. So for example, if you want to buy a residential property that you want to lease out together as a family, you don't want to slip and fall on that real estate to end up then costing you out-of-pocket dollars in liability. So what the LLC allows you to do is hold that property in the LLC along with, you know, all of the lease money that comes in should be in an account in the name of the LLC. You have to really respect the form of the LLC as a separate entity. And then that LLC can pay the expenses of maintaining the property, improving the property, and ultimately can make distributions to the owners. So that's one way that we would typically see co-ownership of real estate. And most of these types of LLCs are going to be taxed as a partnership for income tax purposes. So most, you know, accountants are going to understand how to deal with an LLC and be able to advise you on how best to deal with taxation there. So that would be our, you know, typical reaction to the question, how can I co-own investment property with others? Another question we were asked is whether, yep, go ahead.
Can you just, I mean, I don't know, I think people are having problem hearing. So if you.
Oh, I'm sorry.
Okay, I think this is better.
Is that better? Okay, I'm gonna pull the mic right up to my face. Yep. Do you want me to repeat any of that?
I was hearing okay, so I think you can continue. If people want, they can go back and listen to the recording.
Okay, you got it. All right, so the next question we were asked is whether someone can transfer a residence into a revocable trust during their lifetime. And I think in the chat, actually somebody else asked this question as well. The question we got in advance had the wrinkle, an additional wrinkle, which is what if my house has a mortgage on it? Okay, so typically if you have two US citizen spouses and you own a residence, most people take title to that residence, at least in Massachusetts, as joint tenants. And in particular, if you're married, you take title as tenants by the entireties. And that's just a more robust creditor protected way of jointly holding real estate in Massachusetts. Not every state allows that type of ownership or titling, but Massachusetts does, and most married couples take advantage of that. So we would not ordinarily recommend that you change that in any way to try to fund your primary residence 50-50, for example, into your revocable trust, because frankly, when one of you dies, the other one of you, it's not ideal to have to share or split a house with an entity and have to figure out who's going to pay for the new roof or the boiler that needs to be reinstalled 50-50 or some other percentage. It's not an enjoyable way to own a house. And if it's your primary residence, most people want to be able to feel like they can mortgage it, sell it, buy something else, however they wish. So most married couples, again, if they're both US citizen spouses, and we don't have to worry about that QDOT, then we would just recommend you maintain that, that ownership. Now, when one spouse dies and the other spouse becomes, by operation of law as a joint tenant, becomes the sole owner of that residence, now there's a question of whether that residence should be transferred into that second spouse's revocable trust in order to avoid probate process on the house when the second spouse dies. And typically we talk to clients, you know, we always want to be careful what elderly means. And when we talk about when it's time to think about, you know, planning for probate, people get a little bit nervous. And so I would say I start to talk to my clients about this issue, one, when they're widowed or a widower, and two, when they get to be about 70 years old, we start talking about funding their revocable trust so that we can try to avoid probate on as many assets as possible. And at that time, the primary residence might be something we want to transfer. What happens if the residence has a mortgage on it? Most mortgages, I would say, have what is referred to as a due on sale or a due on transfer clause. And that gets triggered if you attempt to make any unauthorized transfer without the lender's prior authorization. Now, under federal law, there are federally mandated exceptions to that general rule. And one of the exceptions is a transfer by the borrower into his or her own revocable trust, so long as that borrower remains the primary beneficiary and still gets to live in the house. That being said, just because there's a federal mandated exception doesn't mean you should go forward and do it without at least notifying the lender in advance. You just never know, and you don't want to get into the mess of having to argue with your lender suddenly after having transferred the asset into the trust. So what we recommend is if there's a mortgage, reach out to the lender, let them know what it is you'd like to do, get something in writing that says that they're not going to try and trigger that transfer on sale or due on sale or due on transfer clause, and then go ahead and make the transfer if you wish. One thing to keep in mind is in Massachusetts in particular, many towns have a residential real estate tax benefit if you are the owner and the occupant of the property. And if you transfer your residence, your primary residence, into a trust for your own benefit, they may have some questions as to whether you still qualify for that residential real estate tax exemption. And so you want to be sure that you understand your town's requirements to be able to maintain that residential tax exemption and still be able to hold the property in a trust for your own benefit. So that's something to also be aware of before you go and make a transfer. And in all events, make sure you talk to your lender before trying to make any transfer, whether it's to a revocable trust or otherwise. Okay, then another question, we had a couple of questions back to back about retirement benefits. And retirement benefits, Vaishali had referenced it throughout her presentation as being non-probate property. And that's because a retirement account is a contract. And when you open up that retirement account, whether it's with your employer, so it's a qualified retirement plan, or it's an IRA or a Roth IRA at any financial institution where you decide to open that account up, part of the account application is a beneficiary designation form. That beneficiary designation form is a contract between you and the custodian of the account, and it mandates where the assets go at your death. In other words, the will doesn't have anything to do with that retirement benefit, okay? So the contract itself is what controls. This is the same way that a life insurance policy works. When you get a life insurance policy, one of the documents that goes with it is the beneficiary designation. And again, you're naming who will take the death benefit when you pass away. And again, it's by contract, not by your will or trust, unless you name your trust as the beneficiary. So one question we had is, some financial advisors will advise, at least previously had advised, always naming individual beneficiaries of the retirement accounts because they were concerned about the complexities or maybe loss of income tax benefits if you name your revocable trust. Vaishali and I, generally speaking, we recommend to clients, because of the creditor and tax protection she described in long-term trusts, we usually have recommended to clients that they name their spouse for sure outright as the primary beneficiary of any retirement benefits. And the reason for this is that the IRS, the code, has many perks for spouses. And one of the perks is being able to have additional flexibility in how you treat that retirement benefit. In particular, you can do what's called a spousal rollover, make the account your own, and you get all the benefits as if you were the participant who put the money into the retirement plan in the first place. This is fantastic income tax planning, but it's not one size fit all. It doesn't fit every situation. So where we would not want a spouse to be the outright beneficiary is if the spouse is not a US citizen. Again, we'd have to work with a QDOT in that scenario to avoid estate tax being due at the first death. And another situation where we don't typically do this, have the spouse as the outright beneficiary, is if it's a second or a later marriage and there are already children from the first marriage, and you want to make sure that your children from the first marriage end up with the retirement benefits after your spouse has later died. And so in that scenario, if you name your spouse outright, they can do whatever they want with the assets and you won't have any control. The only way to have control over those assets is if you leave them to a trust for the benefit of your spouse as opposed to outright. So generally speaking, primary beneficiary would be your spouse outright, except in certain circumstances. And then we typically recommend that the contingent beneficiary is the employee's own revocable trust. And again, we do that for creditor protection and divorce protection, as well as tax protection down the road, estate and transfer tax protection down the road, to the extent that those assets remain in trust for the lifetime of a child. Recently, the federal government made this choice even easier, leaving it outright to a child or leaving it in trust. There used to be some hurdles you had to jump through in order to get the income tax deferral benefits of leaving assets like this outright to your children versus in trust. But the Secure Act came into play and has deeply, deeply reduced the benefits of leaving retirement benefits out to your children. In large part, it has truncated the amount of time that a child can take those distributions. They used to be able to take distributions over their lifetime, thereby allowing for lots of income tax deferral while the assets remained in the IRA or qualified plan. That's no longer available. It has to be distributed to them within 10 years if they're of majority age. And so it's just not a great benefit anymore. So we would very much recommend, if the retirement benefits are of substantial value, using your trust as opposed to having it go outright. Another question we got is, does it matter from a creditor protection standpoint if I have a qualified plan like a 401k or a 403b, or if I roll that over into an IRA? So many of you have, employer-sponsored plans. Many people leave their money in the employer-sponsored plan forever. They never roll it out into an IRA, but sometimes clients hear from their financial advisor, gee, if you roll the assets into a rollover IRA, we could invest those assets differently than they're currently invested. And wouldn't you want to have a better return than maybe the mutual funds you're invested in? So that's always a question. You should know qualified plans, 401ks and 403bs do enjoy federal protection from bankruptcy. They are unlimitedly protected. So it doesn't matter how much money you have in a qualified retirement plan, you are protected from bankruptcy in federal court. Those assets are protected. The question then becomes, if I roll it over into an IRA, do I have the same protections? And under the federal rules, you do have the same protections so long as the rollover IRA is kept separate from any kind of contributory IRA that you've been putting money into every year. Those two things are different and they are treated differently. So if you commingle them, you may lose some of that creditor protection as a result. In Massachusetts, similarly, you have the same creditor protection from a rollover IRA or from a qualified plan. It's the same rules. But in general, if you have a domestic relations order, so if you're divorced, you can't protect your retirement assets in divorce, and you can't protect them if you have a criminal conviction under Massachusetts law. So in those cases, you lose that creditor protection. Importantly, the Supreme Court, the federal courts have taken away any illusion that a beneficiary who's a child of yours gets any benefit whatsoever from a creditor protection standpoint from an IRA or a qualified plan. So basically, once it's out and it's to the next generation, there is no protection for those IRAs anymore for your kids. And that's because the child is not considered to be a participant or an employee. And so the benefits of that creditor protection are kind of gone from a public policy perspective. And the last question we had was whether employer provided group term life insurance and disability insurance, who should be named as beneficiary of that? We oftentimes will recommend that the life insurance piece of it, the beneficiary be your own revocable trust, the employee's revocable trust. Again, it allows for maximum tax planning. It allows the formulas that Vaishali referred to in revocable trust to be able to be utilized to maximize the use of exemption from the first spouse's death. So we would recommend that for the insurance, the life insurance piece. Disability insurance, if you're disabled, you're getting income basically, and you probably want that to go to your checking account. So recommended that, disability insurance, you just keep that in your name. There's no reason to name your trust because it ends at your death anyway. So whatever payments you're getting are really an income replacement because of your disability. So I don't see any reason to transfer that into a revocable trust. I think I covered the questions that came to us before the presentation and we did have a couple of questions about specific items relating to property and laws in India, which we really can't speak to because we are US trained and licensed attorneys, and we really don't know the intricacies of Indian law and state by state Indian law. So I think those are the kinds of questions that you really want to have Indian counsel to be able to answer. So with that, I'll give it back to Vaishali G, not Vaishali Goyal, but Vaishali G for moderating additional questions that have come in the chat.
Funny how both are Vaishali G, okay. All right, so we do have few questions from the attendees here, but before we move forward to those questions, I would like to call upon, without whose collaboration this seminar would not have been possible, Zahir Sami from South Asian Boston Association, SABA. Just come on, I hear you are there, so please, say a few words here, and then we'll move on to the questions.
Hi, good evening, everybody. My name is Zahir Sami, and I'm the treasurer of the South Asian Bar Association of Greater Boston. You might be surprised to learn that we have an organization of South Asian lawyers. We're not all engineers and doctors. And you've heard from a couple of our fantastic attorneys, both of whom are members of SABA tonight. I also want to thank our Know Your Rights Committee co-chairs, one of whom I see on the meeting today. That's Natasha Meserve, and our other co-chair is Aditya Parakath. Both of them worked with IAGB and Sanjay to organize this fantastic seminar for you tonight. I won't take a lot of time. I just want you to know that SABA is a local organization of South Asian lawyers. We are devoted to advancing the careers of South Asian attorneys and also serving as a resource to the South Asian community. So, and the seminar that you're participating in tonight, I think is a great example of that. We have attorneys who practice in almost all areas of the law, everything from criminal law to labor and employment, business law, and of course, you've heard from our estate planning attorneys tonight. So we have a website, sabagb.org, if you want to contact us about anything, and certainly you can reach out to Suma or Vaishali about any questions you have. I'm sure they'll be happy to talk to you. And again, thank you again to IAGB and Suma and Vaishali for organizing this.
Thank you, Zahir. Thank you for the partnership. And yeah, Aditya has worked really, all this time he is holding our hands and working with Sanjay, bringing us these two beautiful attorneys, giving us in-depth knowledge of the most difficult topic, I would say. So before we go, we have few questions here. One of the question is, what size of assets or the properties would justify having a trust instead of just a will, just passing on directly to the beneficiaries as opposed to keeping it in the trust?
Charlie, do you want me to take that one?
Yeah.
Okay. So it's less about the value of the assets and more about your circumstances. If you have minor children, as Vaishali had indicated earlier, it's very difficult to leave assets outright to a minor because minors cannot contract in this country. That means that they cannot hold title to property. That includes bank accounts. So it's very difficult to leave assets in a responsible way to a minor and not know who is going to be actually controlling that money. So the purpose of a trust in that scenario is to make sure that you might nominate somebody completely different as the trustee than your guardian, because your guardian is who you want to raise your child, but the guardian's going to need money to help support the raising of that child. And that person may or may not be the right person to manage the money on behalf of your child. So it may be two different people you're thinking of who would be responsible for those different aspects of raising a child, getting them to college, paying for all their expenses. But that's the reason that you might consider using trusts. I alluded to the second spouse scenario, second family scenario, right? Where you're no longer in a single nuclear family. That's another reason to use trusts, where you care about what happens when someone after you dies. So if you want to have control over that, you have to use trust. There's no other way to bind that next person who might have, say, a life interest, maybe an income interest in something, but you want ultimately the principal to go to someplace else. So there's no other way to protect that than through a trust. And then third, I would say a lot of our clients, when Vaishali and I are working with clients, we're in Boston, we're a major Boston law firm. Most of our clients are looking to us for sophisticated transfer tax planning. So it's not typically just the folks who are Massachusetts taxable. In other words, a married couple with $2 million. It's usually people who are looking at federal estate taxation. And through the Trump tax code, we greatly increased the amount of exemption. So we reduce the number of people who might fall into that category. But because the Trump tax reform had its own sunset date of January 1, 2026, we're still working with a lot of clients who are more, married couples who are maybe more at the 10 or $11 million mark, as well as those who are well beyond that and doing a lot more planning. We didn't talk today at length about tax planning by making inter vivos large gifts, but that's something a lot of our clients are doing to take advantage of the temporarily increased federal estate tax exemptions. And in those cases, we're creating irrevocable trusts as well as the basic revocable trust planning that Vaishali talked about. So again, it's not really about the asset value, it's more about your circumstances. And it's one of the reasons you should talk with a qualified attorney about what your needs might be to see if maybe a simple will is all you need. And for some clients, that is all they want and all they need. They have, children of majority age. They're not interested in creditor protection or diverse protection of the assets that they leave to the kids. So they'll just leave it outright. And in that case, a will is perfectly fine.
All right. One question that has been repeatedly asked here is, does the will, if somebody has handwritten the will or if they have written it and is witnessed by non-blood relatives, is that okay? Or does it need to be registered, notarized here in US as well as back in India? Like, so does the handwritten document or whatever document which is not really registered is held as an official document, or do you need to have it registered?
Go ahead, Vaishali.
Yeah, so I did see this question a couple of times. So in Massachusetts, at least, so this is all, to take a step back, this is all state specific also. We have this wrinkle in the US where it's not US laws, it's state laws also, particularly in this field, particularly relating to wills. So every state has their own requirements for what will count as a fully executed, properly executed will. In Massachusetts, that means that it is in writing and it's signed by the testator, who is the person, that person's will. And on top of that, it needs to be witnessed. And what we like to do is that it's actually have two witnesses and a notary actually notarize that document. However, you don't actually need it to be notarized for it to be a fully executed will in Massachusetts. So what that means is that if it's witnessed by a non-blood relative, it's not so much that they're a relative or not, they have to not be interested in your will. So they have to not be named somewhere. You can completely benefit, non-blood relatives in your will. So I can't speak to, if in that situation, it might not be a properly executed will, but it can be. So it depends on if that witness who's signing was interested in that, was an interested party in that estate. And I hope that makes sense. So otherwise it just needs to be in writing. It needs to be signed by the testator. There's no registration required. There's none of that. The only time people really should know that you have a will is upon your death. They find the will and then they go file it in the probate court. That is, I think, maybe what people are referring to as register. It registers after your death. There's no need to do it beforehand. You just need to properly execute the will while you're alive. And I want to note that I saw this other question. I really want to address this because I actually meant to say it in my presentation. Using forms online is not a good idea. It doesn't matter. You may, after this presentation, you have some groundwork. That's great. It's groundwork to go get an attorney and have them draft a plan for you. Please do not use online forms. It will not go over well. I have family in Texas, and I myself would also not use online forms to draft up a will in tech. Like it's not a good idea. You need someone with expertise who actually will draft the will properly. And on top of that, like I mentioned, the two witnesses and the notary, it is what's called a self-proving affidavit. So if you have those pieces in place for your will, which your estate planning attorney should have when they draft the will and when you go to their office, now you should be able to go to people's offices hopefully soon. The pandemic is sort of lightening up in the US anyways. And so you can go to the offices, they'll have people there. And the reason you really want that, and you don't want to rely upon this will that someone's referencing where one non-blood relative has signed as witness, your will, if it goes, it'll go to probate and it'll be, what's called probated. What will happen is that if anyone disputes your will and there is not two witnesses and a notary, they will have to find a way to actually validate it to make sure that it was properly executed in that way. If you have the two witnesses and the notary, there's no need for them to do that. They have the information, they have it there. Two witnesses said it was fine, the notary said it was fine, it's fine. If they need to contact those witnesses, they have some of their contact information, but Suma can correct me if I'm wrong. I think if it's there, and the will is fine, you're fine, or well, the people who are taking care of your estate are fine, and it will all be much smoother.
Yes.
So
you're right about that, Vaishali, and I'll just jump in to say that if you have two witnesses and no notary, and you file that will with the court, it's not always that it requires somebody to ask a question. The court may say this is not self-proving, and the self-proving nature is the notary is there to witness the witnesses signing and saying they witnessed the testator signing. So it's like a three-part test, right? If you have no notary, then the court has to call those witnesses into the court to testify that they were there and that is their signature and that they witnessed the signature of that will. What makes it self-proving that everybody was there and signed is the notary signature. So that's why you want to go through the process of getting the two witnesses and the notary.
All right, thank you. Thanks for killing two birds in one stone, Vaishali. The next one, what's the best way to sell the property in India and repatriate the money here? You may not be able to address it, may be able to address it. I'm just going to throw it out there.
Yeah, this would be something I throw back to Suma.
Okay.
We can
no problem.
Too much on, but, yeah.
So generally speaking, the U.S. has foreign asset reporting requirements. They're commonly referred to as FBAR requirements. And so if you're selling property in another country, and it's not just in India, but in any country, if you've got assets outside of the U.S., basically the U.S. just wants to know about it because they want to tax you on it. So if you have property that you're selling in another country and you want to bring the money back into the U.S., there are just reporting requirements and things that you want to do to make sure that that you are saying to the U.S. government what the transaction is and what the proceeds are. So that is a complex process that I don't think we can get into here, but it's something that you should certainly have a CPA looking at. And if your CPA is just, taking your receipts and putting them into TurboTax, then you're going to want an income tax planning attorney to help you with the questions that arise when you have property outside of the U.S.
So the next one is something along the same lines, but now it's related to the gift. So if somebody decides to give you the gifts, can you accept gifts? What is the limit that you can accept the gifts from India to here? What's the dollar limit before it gets taxed? And what's the lifetime limit before it gets taxed?
So the rules that Vaishali discussed about the exemptions, the gift tax exemptions, apply to the donor. And they only apply to the donor if you are a US person. So if somebody is outside the United States and wants to give money to a US person, and they want to do that in a gift capacity, so it's not income for services or anything like that, it's just truly a gift, they are not bound by any of the US gift tax rules because there's no jurisdiction of the US on that person. So they can actually just provide the gift up to any amount for their US citizen or US person beneficiary, subject of course to any rules that might exist in India that might make them, have to pay a tax to make that transfer. Specifically for our clients who are already, high net worth and might already be estate taxable in the US, if they have parents who are outside the country with substantial wealth, we will often recommend to our client, the US person, that they talk to their parents and see if India has a way for them to make that gift to our client in a trust or in some other vehicle where that property isn't actually owned by our client when our client dies. It's seen as being something else, some other holding company or holding trust, so that the client himself or herself isn't deemed to be the owner. And the reason for that is anybody who gives you a substantial gift from outside the country, right? That gift is outside of the US estate and gift tax system. But once it's yours, once you own it, it's now subject to estate tax when you die. So it's much better to be able to receive that gift in a way that it's not actually owned by you, and the US government can't tax you on that asset when you pass away.
All right, thank you. Next one I have here is, do the assets in the trust get counted towards when you are putting the college applications? You know, when you have to declare your property, do the assets in a trust get counted towards towards the assets of the total of the applicant?
Do you want to start that, or would you like me to?
I have thoughts on what I might think is right, but you should go ahead. I think I have the answer, but
yeah. So any assets that are owned by the student obviously are going to be part of that FAFSA application. I think that FAFSA application actually does delve into more than just what's owned by the student or the child. It does get into what the family as a whole can contribute and where those contributions can come from. I haven't looked at a FAFSA in a really long time, since basically I applied when I was going to law school. So I didn't have trust funds. So I don't know the answer to that question, but I think the FAFSA tries to be pretty far reaching to try to understand where there might be benefits. Now, if a child is a beneficiary along with many other beneficiaries of a trust and isn't deemed the owner, for example, can't just take the assets out whenever he or she feels, doesn't have open and ready access to the trust, then I think there would probably be an argument that that money isn't the child's or isn't available to the child without some other third party approving the distribution. But I think you'd want to be very careful what representations you're making, and the trust terms might dictate whether and to what extent those assets would be part of the FAFSA application.
And I think, just to add on to that, I'm closer to the FAFSA process. And from what I vaguely recall is that I think they will ask you because I think the point of the FAFSA is not just to get what your child has access to, but what your parents have access to. They want to see how much your parents have. So that way, theoretically, they should say, oh, well, your parents have enough money, they should be contributing to your college education. So I think you will have to be careful as to see if your assets are in trust, what kind of trust it is, and who it's for the benefit of. So I think it's what Suma mentioned, but it'll be trust specific. And I think it will also be specific to like the parent themselves and their ownership of the trust assets. Because like Suma had mentioned, I think this might be a little bit too, sort of further than what this person is asking for, but like Suma had mentioned, the lifetime gifting and planning, which has to deal with the irrevocable trust. And I think that's where it would get tricky for someone where, do I have assets in trust? Let's say, for example, parent contributed money to an irrevocable trust. It's held for the benefit, it's completely out of their estate, but it's maybe for the benefit of the child. So that will count because it's for the child. But there may be in some instance that a parent contributed to a trust that's for the benefit of, niece A. That's not relevant. It's not in the parent's estate and it's not for the benefit of the child. So that may not count in that instance. So it's very trust specific. And I think if this is a question that is very relevant to you, that would be something that your estate planning attorney could probably, and your income, like your CPA or some other financial advisor, can help you deal with or try to figure out which of those trusts would count for that part of the application. But it's very specific is the general point.
Yeah.
Right. I know we are past the hour. There is only one question, last question, I think, which I haven't addressed. So I'll go ahead and ask that. Can you fund your revocable trust with your 401k or 403b plans?
No. So 401ks, 403bs, and IRAs during the participant's lifetime have to stay in the individual's name. There's no way to actually transfer that while you're alive. So the way to avoid probate on that asset is to fill out that beneficiary designation and have it passed to your revocable trust at your death.
Yeah, and as another note to another question that I saw, just because you have these assets that have beneficiary designations, and you may think, like we mentioned before during the presentation, you may think that everything is good to go and everything is designated, no big deal. There will probably be something out there. Make sure you get a will, and you draft a will, or you should have an estate planning lawyer draft a will and have it executed, because we've all been around for a while now. There are assets that sometimes you just forget, you just don't remember, and they will come up in your estate because it will have to. And you want to make sure that you're fully covered. So please don't take anything about designations as, oh, then I don't need a will. You need a will. Everyone needs the will. That's if you want any takeaway, that's the takeaway. So I just want to end on that as far as questions and answers go.
Yep. And I did see something about, how often should I look at my estate plan? We tend to tell clients about every 5 years, you should dust it off and look at it. Circumstances change, the health of people you've named to take certain fiduciary roles change, your assets change, the tax laws change, the local laws change. And so you wanna take a look at it every 5 years or so. And for some of our clients, no change is necessary. And for some of them, inevitably, things change and they want to make changes to their plan. So it's not something you should put in a drawer and forget about for 20 years.
Yeah. Okay. All right. I thank you. Thank you so much. I know this program has gone over a little, so thank you for staying with us. Thank you for all the invaluable information that you have given us today. And thank you to Saba, Zahir. Thanks for your partnership. And hopefully this was informative to all those who have attended. The recorded session will be available on the IIGB's YouTube channel for you to go and reference back if there are anything that you have missed here or you just want to listen again. So thank you again, Suma. Thank you, Vishali.
You bet, Vishali, and thank you because this will be my premiere on YouTube. So
oh, nice.
Mine too. And remember, if I did speak too fast, I think you can slow down a little bit on YouTube, and I apologize, I guess, after the fact, but hopefully it did fit in all the information. And thank you so much again for this opportunity. We're so happy to have been invited and to speak. This is so important, and we know it's on top of everyone's mind with everything going on. So thank you for inviting us. Thank you for having us, and please let us know if you have any questions. And yeah, we're happy to be here. Hope everyone has a good evening.
Thank you.
Thank
Good
you.
evening.